Hello everyone, welcome to UN Digital Class. I am Rashmi Ranjan Mishra, lecturer and head of the Department of BBA, UN Autonomous College of Science and Technology. Today I am going to discuss the last part of Indian Partnership Act, which is relating to dissolution of partnership firm or the winding of the partnership firm. So here we are going to discuss what is dissolution or winding off and what are the different grounds when a partnership firm is going to dissolve or that going to wind off. That we will discuss one by one. So first we are going to discuss what is the meaning of dissolution. When the relation between all the partners of the firm comes to an end, this is called as dissolution of firm. Section 39 of the Indian Partnership Act 1932 provides that dissolution of partnership firm between all the partners of a firm is called as dissolution of a firm. It implies that the complete breakdown of the relation of a partnership between all the partners. So first we are going to discuss what is dissolution. Dissolution means breakdown or close off. That means when, in simple words, we can say that when relationship between the person comes to end or what they are going to start that and when that is fulfilled or that comes to end, in that case the relation between that particular activity comes to end or that is closed, and when the relation breaks down or ends off, in that case we say that that is dissolution. So in partnership firm, dissolution implies that breakdown of all the partners relationship during the carrying out their business activities. So partnership firm 1932 describes that dissolution of the firm implies when the relation between all the partners in a firm that is going to dissolve or what they are going to start the project or what the objectives they are set in during the formation of the business, and at the end of the business when that objective or the purpose is fulfilled, in that case they want to close down their business, and in that case all the partners they are discharged from each other, and in that case their relationship breaks or comes to an end, and in that case that is known as dissolution of partnership firm. So dissolution of partnership firm basically implies relationship between all the partners is discharged from each other or the relationship between all the partner breaks down. So now we are going to discuss what is dissolution of partnership and what is dissolution of firm. What is the basic difference between dissolution of partnership firm and a dissolution of partnership? So simply we can say that dissolution of partnership and dissolution of firm are not the same. Dissolution of partnership means in that case one or more of the partner is discharged, but others they can continue the firm or they can continue the business, or a new partner enters into the business, in that case that is called as dissolution. But dissolution of a firm simply implies that when the firm comes to end or when the firm closes down. So there are certain basic difference between these two. The first one is that is termination of a business. So in case of a dissolution of partnership, the business is not terminated, but in case of a dissolution of a firm, the business is closed. That is the basic difference relating to termination. That means in case partners may discharge, new partner may be entered into or old partner may be discharged from the existing business, but the business may continue forever when the partners carry on that business. But in case of a dissolution of firm, that implies that the relation between all the partner is discharged or objective is fulfilled and the firm is going to close down on account of different reason, what we will discuss in our next slides. The second point that is relating to settlement of assets and liabilities. When the partnership firm is dissolved or when the firm is dissolved, in that case there must be settlement of assets as well as liabilities. So in case of a dissolution of partnership, assets and liabilities are revalued and a new balance sheet is drawn. That means when a new partner is admitted into the partnership firm, in that case their share of profit or their share of contribution must enter into, and in that case the assets or existing liabilities that are revalued and a new balance sheet is drawn after admission of a new partner or after termination of a new partner. But in case of a dissolution of firm, in that case all the assets are sold and whatever liabilities are there that are settled or paid off, and anything is left that will be taken among all the partners. The third point is court intervention. So what is the court intervention in case of a partnership as well as in case of a firm dissolution? In case of a partnership dissolution, the court does not intervene because partnership is dissolved by mutual agreement. but in case of a dissolution of a firm can be dissolved by the court's order. So this is another basic difference which is very important. At the time of a close down of the business or at the time of a dissolution of the partnership members, there must be intervention is made, but as the partnership is the relation between all the partners, so by their mutual consent or by their mutual agreement, the firm or partnership is dissolved. New partner may be admitted with the consent of others, or old partner may be discharged with the consent of other partners. So in that case, there is no intervention of court. But in case of a firm dissolution, the firm must be dissolved or can be dissolved at the intervention of the court. Then the next one is economic relationship. This point signifies that in case of a dissolution of partnership, economic relationship between the partners continue through in a changed form. But in case of a dissolution of firm, economic relationship between the partners comes to an end. So when partnership is dissolved, in that case the relationship between all the partners that continue as partners are exist. Maybe new partner is admitted or maybe old partner is discharged. So in that case, the relationship or the economic relationship between all the partners that can continue through a changed form, but the relationship is continue at a changed form. That means when a new partner is admitted, in that case there is change, or a new old partner is separated, in that case also there must be a change, and the relationship must be with a fresh or a changed form. But in case of a dissolution of firm, in that case the economic relationship between all the partners comes to an end. As the firm is closed down, there is no existence of the business or the firm. In that case everything is closed down and there is nothing can be left. So the economic relationship that comes to end when the firm is dissolved. And the fifth point, that is closure of books. So in case of a dissolution of partnership, the closure of books signifies that does not require because the business is not terminated. But in case of a dissolution of firm, the closure of a books signifies that the books of accounts are closed. That means when the partnership dissolved, that means either a new partner is admitted or a old partner is separated. In that case, new fresh partnership business is carried on, and in that case when new partner is admitted or old partner separated, that does not signify that the books of accounts of the partnership firm is closed. So the books can continue either at the admission of a partner or at the separation of a partner. But in case of a dissolution of a firm, in that case everything is closed. So the financial books or the books of accounts that must be closed, and whatever amount of profit or whatever money is left, that will be distributed among all the partners and they can take to go their home. And the last point is other dissolution. There are other grounds in which the firm is also dissolved or partnership business is also dissolved. So in case of a dissolution of partnership, it may or may not involve the dissolution of the firm. But in case of a dissolution of firm, it necessarily involves dissolution of a partnership. That means dissolution of partnership does not signify dissolution of firm, but dissolution of firm signifies dissolution of a partnership. So that is the basic difference. That means when partnership dissolved, that does not mean the business is dissolved, but when business is dissolved, in that case the partnership dissolved. The next one is there are different modes of a dissolution of firm. That means when a partnership firm is dissolved or that wind off, there are different grounds when a partnership firm is dissolved. Basically there are two parts where the partnership firm is dissolved. One is dissolution without interference of the court. That means here the court does not interfere. Without interference of the court, the firm is dissolved. And there is another one is dissolution by order of the court. In certain cases the firm or partnership firm is dissolved. In that case the order of the court must be necessary, and by the special order or by the interference of the court the firm can be dissolved. So what are the different grounds where the court does not interfere? What are the different grounds where the court interfere? That we will discuss one by one. So the next one is dissolution without interference of the court. This is the basic part. That means here the court does not interfere. That means with the negotiation or with the mutual consent between all the partners, the partnership firm can also be dissolved. So there are different grounds where the court does not interfere, and in that case the partnership firm may be dissolved. The first one is dissolution by agreement, second one is compulsory dissolution, third one is dissolution on the happening of certain events, the fourth one is dissolution by notice. And a dissolution on the happening of certain events, that is again divided into four parts. One is expiry of the period, second one is death of the partner, third one is insolvency of the partner, and the fourth one is fulfillment of the object of the partnership firm was formed. So in a nutshell, we can simply discuss in detail, we can discuss in the next slide, but I am discussing you in simple words. Dissolution by agreement, that means partnership firm is created by an agreement. So when the object is fulfilled, the firm can be dissolved by the agreement. Then the second one is compulsory dissolution. In certain cases, the partners can decide that their firm is dissolved, and that is known as compulsory dissolution. And the third one is on the happening of certain events. That means when the period is over, the firm can be dissolved. When a partner dies, in that case the firm can be dissolved. When a partner becomes insolvent, the firm is dissolved. And when the object is fulfilled for which the business is formed, that object comes to end. In that case, based upon that fulfillment of object, the partnership firm can be dissolved. And the next one is dissolution by notice. By giving a notice of any one partner or all the partners to others, then the firm can be dissolved. And in all cases, there is no interference of the court. That means the court does not interfere. By the mutual consent or agreement of all the partners, the business can be dissolved. So we can discuss in detail one by one. The first ground, without the intervention of court, that is by agreement, that is mentioned under section 40 of Indian Partnership Act. So what it signifies, a partnership firm can be dissolved at any time with the consent of all the partners, whether the partnership is at will or for a fixed duration. A partnership can be dissolved in accordance with the terms of the partnership deed or of the separate agreement. So by agreement signifies a partnership firm is created by an agreement between all the partners, as that is formed with an agreement or by mutual consent for the purpose of fulfillment of certain objectives. In that case, whether that is partnership at will or whether that is partnership for a fixed period. In that case, when it is created by an agreement, by same agreement, the partnership firm is also dissolved, and in that case, that is called as a dissolution by agreement, which is mentioned under section 40 of the Indian Partnership Act. Then the second one is compulsory dissolution. That means the firm must be dissolved or compulsory that can be dissolved, which is mentioned under section 41. In case any of the following event take place, then it becomes compulsory dissolution to the firm to dissolve. That means when any of the following cases that we can discuss, in that case the firm can be dissolved because that event does not permit to continue the partnership firm. So first one is insolvency of partners. That means in case all the partners or all the partners except one become insolvent. So when all the partners declared as insolvent or any one partner among all the partners is declared as insolvent, that means his liability is not sufficient or his private property is not sufficient to fully settle the liabilities what he has claimed or what he has made. In that case, the partner declared as insolvent, and when a partner is declared as insolvent or when all the partner is declared as insolvent, in that case the partnership firm closed down, or that is called as a dissolution of the firm. The second one is unlawful business. In case the firm is engaged in more than one business which may have become unlawful, the better view appears to be that the firm will not dissolve as to the other legitimate business unless all of them are so interconnected that stoppage of one would paralyze the others. So unlawful means when the business is not carried on in a legal way, that is certain other activities involved which is not legally permitted, or any of the partner disclose anything to others or whatever may be which is not legally taken into consideration, that is illegal or unlawful. So in that case business is declared as unlawful means the business must be closed, and that is called as a dissolution on the ground of unlawful activities. There is one example. A and B charter a ship to go to foreign port and receive a cargo on the joint venture. So here the business is a partnership business or joint venture business. A and B are the partners. War breaks out between England and the country. So the port or the ship taken from foreign country to India or home country. So in that case, during that time period, the wars breaks out between these two countries where the port is situated before the ship arrives at the port. So before arrival of the ship at the destination or at the port, in that case the war breaks out and continues, and that continue the wars until after the time of appointed for loading, and this in this case the partnership between A and B is dissolved. As the wars breaks out between these two countries, home country and the host country, in that case that does not permit to carry on the business, and that is called as a unlawful business. So when war breaks out between these two countries and that is unlawful, in that case the business between A and B, that is dissolved, that cannot be permitted. The third ground is dissolution on the happening of a contingent event. A firm may be dissolved on the happening of any of the following contingent events. So contingent means that may or may not. So if any type of event that is going to happen or going to appear which is not certain, that means that can or cannot be, in that case the firm can be dissolved. So first one is expiry of a fixed period. A firm constituted for a term is of course not exempt from dissolution by any of the other possible cause before the expiry of the term. The contract may expressly provide that the partnership will determine in certain circumstances, but even if there is no such express term, an implied term as to when the partnership will determine may be gathered from the contract and the nature of the business. The provision of this section made it clear that unless some contract between the partners to the contrary is proved, the firm, if constituted for a fixed term, will be dissolved by the expiry of that term. So expiry of a fixed period, that means when the partnership firm is formed for a fixed period by the mutual consent or agreement between all the partners, when that period is over or the object is fulfilled, in that case they think that whether the business it can continue or not. If they think that it is better for them or it is better for all the partners, when the period is over they can close down their business, then by a mutual consent between all, after expiry of the period the business can be dissolved. So unless and until the contrary is proved or there is no such terms and condition is there, so when after expiry of the period the firm can be dissolved, and that is known as the dissolution of the firm after expiry of a fixed period. Then the second one is on achievement of specific task. A partnership constituted to carry out contract with a specified person during a particular season would be taken to dissolve once the contract are closed. So on the achievement of a specific task means when a purpose or object is fulfilled, when the task is completed, or when a specified task what they are going to start that is completed and their achievement is fulfilled or their target is fulfilled. So on achievement of that specific task by all the partners, the partnership firm can be dissolved, and that is known as dissolution of firm after achievement of a specific task. Then the third one is death of a partner. When the deed of partnership did not provide that death of a partner would not dissolve the partnership. The partnership stood dissolved on the death of a partner. Firm stand dissolved automatically on death of one partner. Continuance of a business after such death would not amount to continuance of earlier partner. That means when a partner is going to die or when a partner exists in the partnership business due to any problem, the partner is died, in that case the partnership firm dissolved. But there is no specific provision that when partnership is or any one partner died, the partnership firm dissolved. There is no specific grounds, but dissolved means the old partner who is already dead or who have died, in that case that partner discharged from the business, any nominee is there, they can enter by the mutual consent, or as by the consent of a existing partner they can carry out by the separation of the death partner. So in that case that is known as dissolution of firm, but that is not specific provision is there by the court or by the act that if a partner is dead, that means the partnership firm is dissolved. Then the fourth one is insolvency of partner. In the absence of a contract to the contrary, the insolvency of any of the partner may dissolve the firm. The rule shall apply even though the partnership has been constituted for a fixed term and the term has not yet expired, or has been constituted for a particular venture and the same has not yet been completed. So insolvency, that is one main important part. When a partner or when a person is declared as insolvent, in that case we can say that when the property of the firm or when the property of or private property of a person is not sufficient to pay the debt obligation what he has made during the service period, in that case the partner or the member or the person can be declared as insolvent. And when the court or person is declared as insolvent, in that case he is not capable to enter into the business for any kind of activities. So in that case the rules shall apply that the partnership has been constituted for a fixed term, and when the term has not expired or has been constituted for a particular venture but the venture is not completed, in that case the firm is not dissolved. But when a partner is declared as insolvent, in that case the partnership firm is dissolved. That means separation of that old partner and entered into by a new partner or carry on by the existing partner. Then the fourth ground, that is dissolution by notice, that is mentioned under section 43 of the Indian Partnership Act. In case of a partnership at will, a partner can dissolve it by giving a written notice of dissolution to other partners duly signed by him. Notice must be clear and certain. An oral notice to only some of the partner will not be sufficient. A notice once given cannot be withdrawn without the consent of the other partner. So dissolution by notice, that signifies that, and that is basically applied in case of a partnership at will. So when partnership is at will, in that case any partner, if they thinks that, or all partner they thinks that they are not interested to carry out the business due to any reason, in that case by giving notice to all, the firm can be dissolved, and that is known as dissolution by notice. But notice must be communicated to all the partners. If notice is kept with the existing one partner, in that case that does not signify that dissolution of firm by notice, and oral notice is not sufficient. That must be in written form, and the consent of all the partners must be given, and that can be taken into consideration at the ground of a dissolution. If notice is not given or that is not sufficient or the ground is not sufficient, the firm cannot be dissolved. The second case where there is interference of the court, that means dissolution by the order of the court. Here the court orders to the firm that you are going to close down your business as soon as possible. So there are different grounds where the court order that the firm can be dissolved. One is insanity, second one is permanent incapacity, third one is misconduct, fourth one is persistent disregard of partnership agreement by a partner, the next fifth one is that is continuous loss, the sixth point that is transfer of interest, and the last one is just and equitable ground. So one by one we can discuss all the points. So first ground, that is insanity. In this case the interference of the court must be necessary, and without interference of the court the firm cannot be dissolved. So what it signifies? If a partner, that is not a sleeping partner, that must be very important. If a sleeping partner is there, that cannot be declared as insanity. So not a sleeping partner has become of unsound mind, then the court may allow the dissolution of firm. So insanity, what it signifies? That means when a person having unsound mind or any disturbance in the mind is there, that means that person is not capable to enter into any kind of legal activities. And when a person is unsound mind, in that case the court is declared as that person is insanity. And when the person is insanity or partner is insanity in the partnership firm, in that case the court may immediate order to the partnership firm to dissolve the firm as soon as possible. Then the next one is permanent incapacity. If a partner, not a sleeping partner, same case, not a sleeping partner is coming into this case, has become permanently incapable of performing his duties as partner, then the court may allow dissolution of the firm. So permanent incapacity signifies that if a partner is not capable or permanently not capable to enter into any kind of a business activities, and that partner is not a sleeping partner. If a sleeping partner is there, that is not considered, or court does not interfere. Apart from the sleeping partner, any other partner is there, and that partner is not permanently capable to conduct any type of a business activities. In that case, the court is order that is incapable to enter into the business, and the court may order to dissolve the firm as soon as possible. Then misconduct of partners. When any partner is guilty of any misconduct which is likely to adversely affect the carrying on business, the court may allow the dissolution of the firm. So misconduct of the partner signifies that any partner having any type of a misconduct activities or behavior in the partnership business, that means maybe disclose any information to outsider, or maybe creates any type of rivalries or any type of a disturbance, or whatever maybe take out the profit, secret profits from the business, or not disclose or provide any type of a financial information to the business. In that case, that partner prevails that is going to conduct any type of a misconduct activities, and when any type of a misconduct activities of the partner shows that to all the partners, in that case the court immediately order to dissolve the firm, and in that case the firm is wound up or dissolved. Then persistent disregard of partnership agreement by a partner. So what is that? When a partner willfully or persistently commits breach of the agreement with regard to the matters relating to the business of the firm, any other partner may apply to court for dissolution of the firm. That means one partner persistently or continuously doing any type of a bad activities, whatever may be, that continuously that particular partner does that type of activities, and it is not permitted by all the partners, that is not capable to enter into that partner. That means that is beyond their control. At every time or at all stages, that particular partner does that type of misconduct activities, or persistently or knowingly doing that type of activities. Then in that case, any partner giving a notice to the court and may order for dissolution of the firm, and the court, after consider that is fair and equitable, the court can close down the business by giving a order to the partnership firm. Then continuous loss, the business is carried on year by year, is loss. Their financial statement or the balance sheet shows that negative position. In that case, when there is continuous loss, in every case the business is closed down. When a firm is working in continuous loss, any partner may apply to court for dissolution of a firm. So when loss prevails every year or year by year, the business shows huge amount of loss. In that case, that is not capable to continue the business, and the court thinks that when there is persistent loss or there is continuous loss in the partnership business, or their balance sheet or their financial statement shows negative situation, in that case court immediately order to stop the business or close down the business, and that is a case of also dissolution of partnership firm. Then transfer of interest, when a partner has transferred the whole of his interest in the firm to a third party, then any other partner may apply to court for dissolution. That means one partner share his interest to others without the consent. The whole of interest is transferred of the firm to a third party or to a stranger. In that case, other partner may apply court for dissolution of the partnership business or partnership firm. So there is a diagram, dissolution, that is a case of a new partnership or winding up, and the winding up when is there, that means there is termination, that means the firm is closed down. Then the last one is just and equitable. The court may order for dissolution on any other ground which the court think is just, fair and equitable. That means loss of a total confidence between the partner. So in certain cases, when court thinks that the situation prevails, there must be dissolution. In that case, when it is just, fair and equitable, the court sees that grounds, in that case by giving a notice to all the partners with the taking of consent of all the partners, the partnership firm can be dissolved. So that is known as just and equitable, and the court may order for dissolution of the partnership on that ground. So when partnership firm is dissolved, after dissolution, what are the rights of the partners? That is mentioned under section 46. On dissolution of firm, every partner or his representative is entitled as against all the other partners or their representative to have the property of the firm applied in payment of a debt and liabilities of the firm, and any surplus is there, that is to be distributed among the partners or their representative. So when partnership firm is dissolved, anything that is left as soon as possible after dissolution, the total amount of liabilities or debt must have been paid out of the assets, or if out of the profit. If any profit or surplus amount is there, then that is to be distributed among all the partners. That is the rights. If any partner is died, then any legal heir or representative is there, they are liable to take that amount. Continuing authority of partners for purpose of winding off. After dissolution of a firm, the authority of each partner to bind the firm and other mutual rights and obligations continue notwithstanding the dissolution. So firm is dissolved means the authority of the partners is there, they must carry out their mutual rights and obligations so far as may be necessary to wind off the affairs. So by their rights and obligation or mutual consent, they can continue or they can close down the business and complete the transaction begun but unfinished at the time of a dissolution, but not otherwise, provided the firm is in no case bound by the act of the partner. So that is one important. There is no case the firm is act and who has been adjudicated insolvent. If any insolvent is there, they are not taken into consideration. But this provision does not affect the liability of any person who after adjudication represented himself or knowingly permitted himself to be represented as a partner of the insolvent. So after dissolution, the settlement of accounts must be made between all the partners, that is mentioned under section 48. If any deficiency of capital is there, that means when partnership is dissolved and after pay of debt to the third party have been paid and advance made by a partner have been repaid, the assets are insufficient to repay each partner his capital in full, any deficiency must be borne by the partner. That means after paying off a debt, if anything is there or any deficiency is there, in that case the deficiency can be filled up by taking the partners as capital from their private property, or their property must be utilized to pay off any type of a debt obligation of the firm, and that must be made because the firm is closed down or that is winding off. So all must be settled. That is the duties of all the partners. The assets of the firm are to be applied in paying off joint debts to the third parties. So whatever assets left in the business that is settled or that is realized, and what amount is realized, that must have been paid the debts of the third party. Advance as distinguished from capital of each partner. If any partner taking from the business as advance money, then that must be settled. To each partner what is due from the firm to him in respect of capital. If any partner having any money that has been paid to the business, then that must be taken into consideration or that must be settled down as the close down of the business. After above payments are made, if there is any surplus, then that is to be divided in proportion. So everything settled down. If any amount of surplus is there, then that must be paid, and that must be surplus amount must be distributed to all the partners in their profit sharing ratio, or they can take it equally. So this is relating to the different grounds of a dissolution of the partnership firm, and this is completed. The total partnership act is completed. Next we will go to another chapter that will be discussed in our next class. So thank you all.